managing tough collaborative practice files and taking a compassionate and strategic approach. This session is going to be led by Ja-Eun, Natalie, Derbyshire, Cindy Chisvin, and Matthew Krofchick. And just a reminder, it has been accredited for 1 hour of professionalism content. So without further ado, we can get started with this session. Jane, Natalie, Matthew, Cindy, thank you so much for joining us today for our 4th annual Family Law Now Virtual Summit. We are so grateful to have you donating your time today.
Okay, let's get it started. Okay, so again, my name is Ja-Eun. I am a family lawyer who has always practiced collaborative family law. And I am a senior associate at Russell Alexander Collaborative Family Lawyers. This presentation is called Managing Tough Collaborative Practice Files and Taking a Compassionate and Strategic Approach. So in CP process, what we strive for is a customized, flexible process. And for those of us who went through CP training, we've already learned this. What we learn while we're practicing, though, is how to adapt, really adapt to the unique challenges of every file. The assumption we're making here today is that most, if not all, of those who have joined us have had their basic CP training and that they've had some files, maybe some tough files that we're going to be referencing today. We will be discussing some unique challenges without specific client information, of course, that each of us have faced and the lessons that have stayed with us. So we as CP practitioners who've learned to adapt to challenges, we're going to be talking a little bit about ourselves too, to make sense of our own experiences, because we're all people with very unique skill sets, some flaws, and distinctive styles. We're here to have a frank discussion about what each of us can bring to the table when things get tough. So now I'll ask each panelist to please introduce yourself and say specifically what your distinctive personality is in terms of how you practice. So Natalie, can you start us off?
Absolutely. Hi, everyone. I'm Natalie Derbyshire. I'm a senior associate at Russell Alexander Collaborative Family Lawyers. In the past, I've served on 2 different collaborative boards, that of Toronto and York Region, and I was called to the Bar of Ontario in 2006. I've been practicing collaboratively since 2011. My strengths as a collaborative lawyer are, I believe, that I listen more than I speak. I'm an empath and I'm highly intuitive. Knowing the facts of the case, I find is, of course, of importance, but navigating the emotions of the clients and anticipating their reactions is what's important, in my view, to understand the likely trajectory of the case. And it's paramount to devising a strategy and canvassing sound solutions. I double majored in sociology and law and society at York University, and the bulk of my elective courses were in psychology. I believe this gives me a bit of an edge in understanding the family dynamic and identifying triggers that may hinder or facilitate settlement. I bring compassion and heightened awareness to issues of disability, mental health, and intimate partner violence. Over to you, Matt.
Thanks, Natalie. My name is Matthew Krofchick. I'm a business evaluator and accountant. I'm certified in financial forensics, and I have a designation from FIDRIO, meaning that I specialize in family and estate cases. I am the chair of the Family Dispute Resolution Institute of Ontario, and I sit on the executive of the Grey Bruce County Collaborative Group and a member of the Toronto Collaborative Group. I've done numerous presentations to OACP and OAFM, and my role in this whole thing obviously is the financial side. I'm doing business valuations, income valuations, and tracing assignments for collaborative files. My big focus is always settlement. That is what my end goal is. I'm always trying to figure out what is the best that we can do to get the clients to the end. And the end is a settlement where people can continue to move on. I believe in trying to minimize the trauma to families as much as possible. So really looking at what is important, not just doing work for the sake of doing work. It's about doing good work, and not just doing good work as in getting the numbers correct, but doing good work as what do the family actually need as opposed to what do they think they need. And so I like to really focus in on that. Jane mentioned something about flaws. I don't know what that's like. I'm perfect. At least that's what my wife tells me all the time. And so, it's when we're dealing with families in these situations, it's about, as Natalie said, listening and understanding. And that gives us some empathy to help drive these families in the right direction. Jane, why don't you tell us a little bit more about yourself?
Okay, a little more about myself. After taking a course on collaborative law at Osgoode Hall, I knew that that's what I wanted to do. So CP is what I've been doing since I was called to the bar, which is why I don't ever have hesitations about advising clients that a collaborative process is the way to go in most files. I would say as a CP lawyer that my strength, in my humble opinion, is that I'm able to see perspectives from different angles simultaneously. I think it really is an ability that I attribute to somewhat of a disability, that is of having some ADHD, therefore being a nonlinear thinker, which I admit used to hamper me, but now I've learned to harness it, incorporate it as a skill in life, and in particular to practice CP effectively. In addition, I identify someone who is kind of direct in communication style. Not that that's always a good thing. Unlike Matt, I can acknowledge my flaws, right? And I think it's not always a good thing because sometimes the other lawyer may not appreciate what they sometimes think is demanding. So I often have to check myself using I statements just as we coach our clients. I would say I also bring an extra sensitivity to EDI issues, and in particular LGBTQ issues, to my files because one of my kids identifies as being part of that community, the LGBTQ community, which I want to embrace and celebrate. So that's a little bit about me. Cindy, please tell us a little bit.
Last but not least. So I'm a psychotherapist and I have a master's in clinical psychology from U of T. And the focus of my master's degree was on family dynamics and child and adolescent development. I also trained in basic and advanced mediation skills. I took that training with Barbara Landau many, many years ago. I was also a professor for 16 years. I taught psychology and sociology at both Humber College and at Seneca College. And that gave me not just the academic knowledge, but the way I related to my students and listened to my students. I had many students who would come and talk to me about interpersonal issues. So that enhanced the skills that I bring to my role as a neutral family professional in the collaborative field. I have practiced for over 35 years in psychotherapy and specifically over 10 years in collaborative practice. I was the former chair of York Collaborative Practice, and I currently sit on the board of both York Collaborative Practice and Collaborative Practice Durham Region. And I'm also a member of the Ontario Association of Mental Health Professionals. And I champion for mental health initiatives and taking the stigma away from people with mental health challenges. And I bring that perspective into my work as well. When I'm working with families, I work with parents in helping them create parenting plans that focus on the needs of their children. You know, I have a philosophy that a child has a birthright to have a healthy, loving relationship with both of their parents, regardless of how their parents feel about each other. I coach parents on how to effectively co-parent for the sake of their kids, and I support the difficult emotions that clients experience as they navigate through the separation process. How do I describe my personality? I'm very caring, I'm very warm and compassionate, but I'm not fluffy. So, which means I'm able to have the difficult conversation with a client to help them move forward in this process if I need to. I can, with care and compassion, help them understand where they are stuck. And I think having sometimes a little bit more of a direct approach serves our clients best. That's about me. So as we're moving through this program, first question that I want to ask is, What is the one big difference between collaborative practice negotiations and negotiations in a litigation context? And Matt, I'm going to throw this question over to you to answer first for us.
Sure, thank you. So my experience is obviously quite different than maybe Jane's and Natalie's as being a financial neutral. So when I'm hired in a litigation context, sometimes it's jointly, but often it is not. So when we're negotiating, likely there's another valuator on the other side of the table. So right then and there, you've got positioning on the valuation side. Even though we are supposed to be independent experts, it just comes with the territory. And so when we're in a CP file, it gives us much more flexibility than when we're in a litigation file. So what do I mean by that? Firstly, we're looking out at what is going to help both parties, right? In a litigation file, that might not be the case. I might not even have any information related to the other party whatsoever. So how are they going to fund the EP, for example? That's something that we may end up helping them with. Looking for options in that. Are they going to go to their RSP? What is available to them, and how are we going to do this? We're in the same room, right? So we're having a conversation where it's not just necessarily siloed like it generally is in litigation negotiations. We're in the same room, and the parties can ask me questions at the same time and hear my answer to both, to their questions, their lawyers' questions, and the other side's questions. We have a pre-meeting. We get to discuss these things amongst the professionals generally and say, what are the areas of concern that we should be looking out for? How do we want to necessarily not script, but direct the meeting to help best suit this couple that's going through this? We're always looking at the situation from a much broader lens, whereas when you're in a litigation focus, it's really, what have you been given? What information do you have about this client? What is it that we've been told? How do we write our report based on that? And then what are we showing up with? And so if you can imagine where you have two valuators who have been given two wildly different set of assumptions, you're going to have two wildly different reports. And sometimes you have reports that are just completely not based in reality, but that's what evaluator has been given and asked to assume. And, the justification might be there for that. Whereas in a collaborative approach, that tends not to happen as much because both lawyers are there from the beginning and they get to say, okay, well, these are the assumptions that we're going to make, or here's the situation. And while we might do an A and B scenario, it really gets rid of this valuator said this and that valuator said this, and it brings down the temperature in a lot of negotiations. Jane, what's been your experience with this?
Well, in my view, the difficulty in collaborative negotiations as opposed to a litigation negotiation, from what I hear and what I experience, is that there's no real playbook here. I have a colleague, for example, who only litigates even though she's been trained in CP, because she says she doesn't know what to do in a CP file. There are no specific collaborative family law rules as there are in litigation. And she's right. There are no specific rules, only principles like transparency and guidelines regarding like respectful communication, for example. So the big difference, in my opinion, is that if you practice CP and you want to get good at it, you have to continuously learn through training and practice, being really mindful of the particular CP negotiation context. So of course, in any negotiation context, it's very important to build a good rapport, first of all, with everyone you're dealing with. In CP context, this means the other CP lawyer and the neutrals, your team, as well as the other spouse. To do that, I think the most important thing is to approach every dialogue with empathy, which I understand to be the ability to see the world through other person's eyes. For example, the lawyer on the other side. It's important for me to be able to understand who they are, which informs, after all, how they are looking at the issues. More specifically, for example, to see whether that lawyer will respond more readily to a legal model argument rather than one based on an equity principle or an emotional argument. And if you have determined that the lawyer will respond better to a legal model argument, you have to frame the issues of your client within the context of the law, even if it's at minimum just a reference to the law. That way, if your argument makes sense to the other lawyer, that lawyer will be more inclined to bring it to their own client and work with you on that issue. So to give a more specific example, if it's an issue around entitlement to spousal support and my client is the party seeking support, I wouldn't be saying, well, it's only fair, or that my client will be upset, because that may all be very true, but it's not going to have an impact on the other lawyer. So I will instead apply my client's specific circumstance to legal entitlement bases, whether compensatory or non-compensatory arguments, and do a lot of calculations maybe ahead of time to show different scenarios to the other lawyer. That way there is more likelihood that my client's interests will be heard. Of course, what you are also trying to do at the same time, however, and this is very important, is to keep in mind that the other lawyer also has to serve their own client and respond to their own client's interests. Because in the end, there is no settlement if only one person gets their way on every issue. Cindy, what do you think is a major difference between negotiations within different contexts?
So for me as a family professional, first of all, I'm a neutral and I am jointly retained by both parties. I work for the family. I don't just work for one side against the other, which tends to be what the litigation model prefers. And I have the benefit of speaking to both parties. So when it begins and when I'm retained, I will conduct an intake, a confidential separate intake with each person, with each client. And these will occur before a full team meeting. So I speak to the clients about their goals, their interests, their concerns. I screen for if there's any kind of serious challenges, and I'll get into that in a minute. And then once I've had this meeting with the clients, I will then schedule a professionals meeting with the lawyers and the financial professional. And in that meeting, I will catch them up to what I've heard from the clients, where there might be some challenges, where there might be some concerns, where we might run into certain blocks because of the way a client is feeling. And that way the team can strategize on how we're going to approach this file, and we're going to design this file to best meet the needs of this family. So as was mentioned earlier, collaborative practice process is not a one-size-fits-all. It works to meet the needs of the specific family, and us as the team of professionals will guide what that will look like. In my intake meetings, I am able to identify where there might be certain triggers that might impact the process. For example, if there are infidelity issues, if there is some financial disagreements. Different parenting styles is a big one when it comes to talking about parenting plans and schedules, different views on best interests of the children. Every parent tells me they love their children and they want what's best, but then they have a very different definition of what that might look like. I also, in my intakes, screen for concerns such as power imbalances, intimate partner violence concerns, drug and alcohol issues. These challenges do not necessarily exclude a family from participating in the collaborative process, but they do need to be addressed. And this is where the professional meeting prior to a full team is important, because then I can catch the team up to what they need to be aware of so that we ensure that the safety needs and all of the needs of the clients are protected, and that we're able to move forward in a way that serves the best interest of this family. Once I begin working with the clients on a parenting plan, I do this offline. I don't do this in team meetings. I do this in separate meetings with the clients outside of the full team meetings. And I emphasize to the clients that it's the parents who should be making the decisions for the children. It's your children. You should be deciding how you're going to continue parenting them post-separation. In the litigation model, you have a stranger, a judge, who doesn't know the family, doesn't know the children, doesn't know the backstory. Because they're going to turn around and make these decisions for what the family's parenting plan is going to look like moving forward. I work with the parents on building trust, learning how to co-parent, to put the emotional, physical needs of their children as a priority in all agreements. I also work with families where there are no children. And the benefits of a family professional on this is to the benefits of family professional in this is to address fears tied to money. So we do know that there are a lot of fears in and around money. Collaborative practice is a more of a flowing process, whereas court is more black and white. It's based on law rather than the needs of the family. It's a win-lose process. It can trigger conflict, anger, and resentment, and the parents lose their voice. In collaborative practice, parents still have a voice. The clients still have their voice.
So we'll move on to the next question.
Do you want me to jump in there, Jane? I didn't contribute yet.
Yeah, please.
Okay, thanks. So for me, I would say I find that CP negotiation takes the pressure off of people, which is fantastic because they tend to make better legal decisions when they're not under pressure or feeling anxiety or stress. That's not to say that the collaborative process means that people don't have the jitters or nerves when engaging in negotiations, but I think that they feel more comfortable overall with the setting and the protocols. And that's because everything within the process is without prejudice, with very minor exceptions, which I won't get into. And CP to me is like an open-handed game of poker. I explain it to clients as a very open, honest, and transparent process that's based on interest-based negotiation as opposed to rights-based negotiation. And clients tend to like it because they're able to be creative about the solutions that they formulate and they maintain control over the outcome, much like Cindy just mentioned. The other great thing is we can be out of the box in terms of what we come up with and brainstorm for the family. It can very much be custom-made solutions. So, for example, we can put funds that would ordinarily be paid to one spouse in a legal outcome in court. Instead, apply it to an education savings account for the child. That may be one type of compromise. Or instead of selling the home, there may be feasible solutions for a buyout of the home if there's a deferred sale, flexibility in paying installments, or a vendor take-back mortgage, for example. CP ultimately allows for brainstorming as a team, and it avoids pitting spouses against one another. And it also helps people co-parent down the road together by improving their communication skills. So Jane, I have a question for you. How do you work with counsel of different experience and perspectives in CP?
Oh, wow, that's a big question. So I've been on files where maybe in the beginning there was little or no trust with the other lawyer. I mean, you're both retained, so you have to work together, but you're trying to sort of figure out, how to navigate sort of the negotiation process that we were just talking about. And sometimes there's a little bit of awkwardness for a variety of reasons. One might be because for the other lawyer, it might be their first CP file, for example. And some first-time collaborative lawyers I found tend to question everything. For example, they might say, why do we need a financial neutral when, my client is very savvy with numbers? So something like that. And I think that in general, when I hear questions like that, it's sort of a mistrust of the process and not seeing the value of professional neutrals. And that might just come from a feeling they may not be able to protect the interests of their own clients if they're not involved directly. So if the other lawyer has this sense, it's also hard for that lawyer to persuade their own client to retain a neutral professional. They might also be thinking that their client will not want to spend the money on a neutral when in fact, a neutral professional often saves clients money in the long run. We see this all the time. But on the whole, I have to remember I've been there too, where the new CP lawyer is when I was in the earlier stages of my practice. And I have to keep this in mind what I've learned throughout though is to trust the process, trust my team. And the most important thing I can do in a scenario with a new lawyer is sort of to be steadfast in my responses, be patient, and also recommend oftentimes to the other lawyer that they seek the opinions of other collaborative professionals that they trust. That way they don't have to take my word for it when they're really looking at me as the opposing counsel. I always keep adding to my personal database senior practitioners who are willing to mentor and have offline conversations with new CP lawyers. That's the other thing I should mention. For all of us, I mean, I think our collaborative community is very strong. I know that, for example, I can call Matt anytime and he's going to get on the phone with me like quickly to give me a quick answer. Cindy as well. So that is something that is very, very rewarding in this kind of practice. Nonetheless, sometimes there are challenges between two lawyers because you just don't see eye to eye. And, although we're professionals, we all have some personal differences. And in this scenario, I have to keep in mind that it's a question of two different approaches and not one of being right or wrong necessarily. So by way of example, I was recently on a file with a very experienced CP lawyer. And on that file, I try to insist on a particular neutral to join that file. And my insistence, no surprise in hindsight, was met with resistance. Yes, it was partly because trust hadn't been established yet, but also because I was insisting on one person. When I spoke with a friend, senior CP lawyer, they told me that they always recommend more than one neutral as a rule because nobody wants to be told what to do and there needs to be a choice. So in my mind, I was only insisting because I thought that was the best and most efficient way to proceed. But in the end, I learned to let go of it. I also made sure I communicated to the other lawyer that my communication style on this issue wasn't meant to be disrespectful in any way. So you have to be fluid in how you're navigating every circumstance. Natalie, how do you handle working with different counsel?
So I try to stick to the Four Agreements, which is a book that I once read by Don Miguel Ruiz. The first rule that I stick by is do not make assumptions. This one is pretty key because I've made that mistake in the past. I try to remind myself that my client's perspective is not their spouse's perspective, and maybe I know things that the other counsel doesn't, or vice versa. And so it's always good to ask questions, particularly when in doubt. And it's also good to be open to new perspectives. I try to be very open-minded. It's good to share our past experiences, particularly in collaborative practice, and discuss our concerns and hesitations as a team. This ultimately, I feel, enables us to be more proactive instead of reactive. The second rule I live by is to avoid taking things personally because we all come from different experiences and backgrounds, and it's really easy to misinterpret what somebody else is saying. So, in order to try to get on the same page with somebody, I try to listen, as I said before, more than I speak. And I remember that there's always more than one way to slice a lime. As a third rule, I know I must be impeccable with my word. It's really important to manage not only the expectations of our clients, but also the expectations of the team. So I try to undersell and over-deliver. I know I can't control my client. And so if I don't know that they're ultimately going to follow my advice, I try to make the team aware that there may be some hurdles that we have to face. And by having our team members aware of that, we're in a better position to pivot when necessary. And then the fourth rule is always try your best. And I do think as collaborative practitioners, thankfully, we do strive to do our best for the families that we're serving. Trained collaborators, I found in my experience, are highly collegial with one another and ultimately want to model best behavior for our clients. The best part of CP is that we can rely upon our team members to troubleshoot and also think of things that may not necessarily be at the forefront of our minds. So I'm so happy to lean on my interdisciplinary team members, the family professional and the financial professional. PTO meetings are also critical. These are professional team only meetings where we're able to advance different ideas with one another, check in, and make sure that we're all in a good frame of mind. And debriefing is also, I feel, paramount for us to be able to support one another and keep up the momentum on the matter. Cindy, what are your thoughts on this question?
So we all come to our teams with different experiences and different perspectives and different ideas. Having the PTO at the start of a file is key on learning about each other, asking questions, understanding the differences we have, and then creating mutual trust and respect for those differences. Sometimes as a family professional, I find that my role entails managing these differences within the team. So bringing together where we have common ground is important. And then also understanding how these differences might be a challenge. Sometimes I have to have, and I have found, have to have confidential meetings offline with a particular professional because of the differences. And then talking about how do we strategize? How do we manage this? How do we go forward? What needs to be said? Is it a joint email that needs to go out? Is it my bringing up a certain topic at the next PTO meeting? That we can address these issues so that we can support the family that we're working with. Another key tool, and you mentioned it a little bit, Natalie, is the pre-brief and also the debrief. So pre-brief is the meeting we have before a team meeting, where we strategize, we set the agenda, we talk about what we want to accomplish. We as the professional team talk about our goals and interests. And the debrief is, how did the meeting go? What did we do well? What could we have done better? And then creating strategies for how we can do better in the next time, because we can always improve. Open and respectful communication is essential to identifying and addressing these different perspectives and finding the solutions. It's also important to recognize that each team member adds value to the process, regardless of our experience. We can all learn something, regardless of how long or short we've been working as collaborative professionals. And Matt, what are your thoughts on this?
So I look at it, I do a fair amount of litigation. And so I always am kind of looking at one to the other. And the nice part about CP is that generally, not always, but we get to know each other through collaborative events. And so right off the bat, it helps break that tension, right? For the most part. And so I find that it allows me to be flexible in how I deal with situations. So, you know, having met this person before, if not, obviously I'm introducing myself. It's about being adaptive to them and understanding their background. And so if we have a practitioner who has just come from the litigation world and all of a sudden they're starting CP, they might not be quite as comfortable in the team setting yet. So it's about letting them maybe catch up with the rest of us who have had more experience with that. It's about being adaptive, but providing my input, right? I'm there not to be a yes person. I'm there to provide my input on these things and make recommendations as needed. Do we need to do this work? What years do we need to review if we're looking at income? What's the relevant purpose of this? Do we need a forensic tracing of some sort? What's the outcome that you're hoping to get? And talking through with them. And so sometimes when we start a file, we might say halfway through, you know what? We don't want to look at that anymore. That's not as relevant as what we once thought. And so we'll switch and we'll change the scope. So it's about also being flexible in how we approach these things and not being so rigid. And that goes for how we deal with lawyers with different experience. We all may have dealt with things where it's very straight and narrow and it's always this way. And then sometimes we have to be able to pivot and turn. And so it's being responsive and understanding the communication styles that everyone has. Some people love to be, you know, I want that follow-up every week. What's going on? tell me, ask me for that information. And there's other people who are, leave me alone. I will get to it and you will get your email. So it's about understanding the different perspectives of counsel and then trying to adapt to that, but at the same time, trying to push the whole process forward as best we can. So that's from the lawyer's perspective. Now, from the client's perspective, how do we navigate a difficult situation? So Cindy, why don't you go first on this one?
Thank you. So I'm often able to ascertain how difficult a file might be from my intake meetings because, again, I'm able to understand a client's goals, interests, and concerns. And I share this with the team so that in a PTO, we can preemptively discuss how to address this if it does arise. In team meetings, I always set up breakout rooms so that I can have a confidential and supportive conversation to understand why a client is presenting as challenging. Sometimes it's just myself who goes into a breakout room, myself and the counsel, the financial neutral as well. But again, the breakout rooms give the client a safe space, a confidential space to talk about what's troubling them, what's triggering them, what's causing them to appear challenging, and to feel heard. Because for clients, feeling heard is one of the most important aspects of this process. If a client feels they've lost their voice or don't have a voice, they will shut down. And when a client shuts down, that's going to make them appear to be challenging, and it doesn't help the file move forward. Outside of team meetings, I will schedule one-on-one meetings with a particular client, again, to give them a confidential space to talk about a concern, whether it's concern about what's being discussed, a concern with another professional, or just a concern about the process itself. Once they feel heard, they're able to talk it through, they're able to understand somebody else's perspective, they often are able to come around and negotiate in the team meeting in a very effective way. If there are children involved, helping clients stay focused on their kids and on best interests of their children is one of the key ways of reducing some of the challenging moments in these files. Discussing parenting time and to a lesser degree decision making creates a lot of difficult emotions for most parents. Helping them feel that their voice is heard and that they will be able to make better decisions for their children moving forward often calms them down. One of the things they find hard is that they know that post-separation, there are going to be experiences with their children that they're not going to be a part of. And it's those emotions that sometimes get in the way of helping them achieve some certain results and settlements in the file. If clients are unable to accept my recommendations, I will reach out to their respective counsel and the rest of the team for support. Addressing challenging clients is a team effort. It's not just on one person. We are all part of this to help the process move forward, and I look to my team for the support in this endeavor. Natalie, can you guide us through your thoughts on difficult or challenging clients?
I'd love to. Much like you, Cindy, I encourage triad meetings. If there's an issue that arises or somebody can't seem to accept a proposal or solution that's being put forward, I want the client to be able to canvas issues openly with the neutral. Often there are questions that I don't know to ask, frankly. And so by having a meeting with you or with Matt to maybe explain, hey, why does this make sense in the financial report? Or, how did you come up with this figure? Or what formula was applied? Or in Cindy's case, why is it that you feel this is in the children's best interests? That can be a conversation that is very eye-opening because although I may think I'm asking the right questions, often it requires the expertise of the parenting professional, I'm sorry, or the financial professional to give some insight and hopefully shed some perspective on the situation. I write reporting emails to my client so that there's a solid record of my advice that I've provided. I actively listen to my client and I do acknowledge and validate them whenever possible and appropriate. But I also acquaint my client with their BATNA, which is their best alternative to a negotiated agreement. I aim to understand my client's hesitations and reluctance, where they're coming from, and hopefully get to the root of the problem. But I also give them a cost benefit analysis so that they're understanding the estimates of the costs moving forward and how much any particular position might cost them if they were to withdraw from the collaborative process. I think it's important for them to understand the raw financial implications of being intransigent. By managing expectations from the outset, there are fewer surprises for the client, and ultimately, I do find we can usually get over those hurdles. Matt, what do you do to navigate a difficult situation?
Yeah, I would say first and foremost, it's about listening. It's finding out what the situation is. Why is there this difficulty? Is it a mental health issue? And I should say that's another difference between maybe a litigation and a CP file. In a litigation file, I might not find out that there's a mental health issue. But in a CP file, I would more likely than not, find out about it and find out about it earlier. So what is the driver of this difficult situation? Is it something related to my work? Is it something related to something else that's going on in these people's lives? So once we find out what's really going on, then the question is, how do we address it? Is this a situation where we need to apply a little bit of pressure? They're having a really hard time with disclosure. Can we talk to their accountant? What other services can we provide to move them forward? Is it that they don't understand what I'm asking for or why we're doing this? Is there an education piece that we have to provide? Do we have to sit down and say, the reason that we do the support calculation is because you have to pay child support? And not to say you don't want to, but this is just part of the process. And we need to know what your true income is because what you've written down on your tax return is not what your income is under the guidelines. And so there's always this piece of education that I might have to do for people when they kind of reach this point. It's steering them in the right direction, saying, okay, now you've told me what the problem is. Let's find out what we really need to do. And to Natalie's point, there's a cost benefit to everything that we do. Is it worth going back a few more years and looking at income? Is it worth doing forensics? What is it that we're trying to achieve? And how much is it potentially going to cost you? And what's the benefit that you're going to get from it? We need to potentially provide options. Okay, you've said that there is unreported income, and other spouse say that there's none. And before we undertake a very expensive review, why don't we talk about what options are available to you so that we can get this done in a timely manner and not cost a lot of money compared to doing a full forensic review over many, many years. Really, at the end of the day, we want to try steering them to settlement as much as we can, get our report done as fast as possible, not because we just want to move on with the file, but because that's the benefit to the family as well. The longer these things drag, the harder it is for people sometimes to settle and get to that point. So, it's identifying, listening, and then providing options for them, and then trying to get them to that end point. Jane, how do you deal with these difficult situations?
So all of those things are so important, Matt, and all of the things that Nat said and Cindy. I think for me, I have to always remember to be respectful. So to be very respectful to our clients' choices, no matter what the situation is. So sometimes we do have a client who's not able to accept the recommendations of the team, though. And yet, of course, we have to be respectful of their choices. But at the same time, we have to figure out what to do about the process. So when the file is not going smoothly, we do have to try to intervene. That's what our PTOs are for, to figure out what the next step is. And it helps if we can do it as early as possible. So knowing how early, I think it's a tricky thing. It comes from experience. And even with experience, you may not always get it right, but it is good to be mindful from the start that there might be a need to shift in the midst of a collaborative process. And when intervention does become necessary, for example, there might be a roadblock where the parties are very far apart on the range of settlement. What do we do in this case? Well, when this is happening, or better yet, when it's likely to happen, an outside litigation opinion supported by the team, both counsel, might help. The important thing here is still to be working together as a CP team to make joint or team recommendations to do this. Otherwise, you run the risk of one party going off and obtaining an opinion, then deciding unilaterally to make changes. and the other party is just blindsided. And sometimes you're at an impasse. A shift to a mediation process makes sense. That is a shift to a mediation process within a collaborative process, though. There are really good mediators out there. A lot of them have CP training, and they can offer assistance by looking at the issues with a fresh perspective, but also respecting parties' wishes to stay within the collaborative process. So within this shift, it's not a whole new process, but a continuation of the process with same lawyers, but adding another strategy, in effect, to overcome an impasse. And I have heard when I've suggested this to some lawyers, they say it might be too expensive for the clients to enter mediation after CPS started. But I have found, I've done both, stay in a process where it's still tough or shift. And I found it's often less expensive to go through a mediation route or try something different than keep hammering away at something that may just not be working for both clients. Okay, so we're gonna move on to the next question. And the question is, how do you work most effectively with neutrals, whether that's a family neutral or family professional neutral or a financial neutral? What happens what happens potentially when the clients are not working well with the neutrals? Natalie, do you have any thoughts?
I do. So first and foremost, I would say I have an open door policy. I am a big believer in frequent communication with neutrals. I know that some team members are not always fond of the idea of offline communications between one lawyer and a neutral, and so involving both counsel often has a better, I guess, feeling or vibe to it, and that's okay. I just think that the regular contact goes a long way in making sure that we're moving along at the same pace and we're on the same page insofar as possible. So I do talk to the neutrals frequently with and without my client in advance of full team meetings to avoid misinformation and to also all be aware of anything that's transpiring or potential issues that may be arising. I try to discover why there's a rocky relationship between neutral and client if it exists. If it's a lack of responsiveness, then I know I need to step in to help my client perhaps complete their homework or whatever next step is required of them. If the neutral and the client don't see eye to eye, I can often help ease tensions by facilitating communication or perhaps softening messaging. I can welcome my client to discuss calculations and options in triad with the neutrals, and I do think it's important for a client to have their questions answered. This can also be an informal setting in which they feel comfortable, maybe asking vulnerable questions. I also encourage my client to discuss goals, interests, and fears because I find that this helps develop a rapport between the neutral and the client. And it can also help neutrals gain an understanding as to why some solutions being proposed are unappealing or anxiety inducing for the client. Neutrals are often able to then tweak their proposal, or they may perhaps suggest, with the help of the team, that a second opinion or a joint opinion may be helpful. Matt, what's your perspective on this?
I mean, I'd like to believe that I never have an issue with a client, but the reality is that, and I'll kind of answer this in the reverse. I'll start with, what happens when something's not working well. Typically, the issue relates to disclosure. That's probably the number one issue that we see. And in this case, it's not so much that the client isn't working well with us, it's that either they're going back to a time period where they might not have a lot of information for, or they're not ready to take on that homework that Natalie's talking about. They maybe haven't paid their accountant, or they haven't really put their mindset, their books aren't up to date. This is creating pressure on them or stress. And so it's about walking through the process with them of, okay, this is why we need this information. If this information doesn't exist, what information does exist? Who can we talk to help you get this done? And so there are times when I'm talking to the accountants directly saying, okay, tell me about the situation. How far back have they not filed? And so on. So it's about piecing together what we can, and then trying to figure out if that's the roadblock. Sometimes it's about providing options and saying, okay, I understand your concern. You feel that this isn't addressing unreported income. Okay. So again, going back to that cost benefit, how do you want to deal with it? Here are your options that are available to you. And because we're in a collaborative sense and everyone's sitting around the table, virtual or in person, the other side can hear those concerns and then we can address it all together, as opposed to sometimes when it's what's going on in one room, no one has an idea in the other. And so the next part of it then relates to how do you work most effectively with a neutral? Well, it's about open communication, hiring us early. And that tends to happen in the CP process, which is a good thing, and litigation does not. We're usually hired towards the end of the process. But by hiring us early, we can actually run through those options at the beginning as opposed to at the end. So we all know what goals we're trying to achieve, and we can pivot if needed, but we all have an idea, this is what we're trying to get done. And so if you hire a evaluator early, then you've got that input on what are the financial issues and how are we going to address those and what kind of report needs to be done. And when I say what kind of report, it could also mean, is this an oral report or a written report? What are the benefits of each of those and what are the costs associated with them? Another big thing is communication, right? How do you want to communicate? Is everything open communication for all parties? Am I allowed having a conversation with the accountant or the business owner to find out about something? Does every person need to be on those communications? Again, what is the cost? What is the benefit of each of those? Sometimes people say, listen, just find out the information and whatever you use, put in your scope, and that's what I want to look at. I don't need to hear them say X or Y. I just want to know what the final verdict is and what you base that off of, right? So it's about understanding this. It's building that framework in. And if a client has a particular need, to understand that need and to make sure that we're addressing that as best as possible. So, I go with the keys here are figure out your scope, figure out the disclosure, open lines of communication, and that tends to make us work in the most effective way possible, and not being afraid to pick up the phone and have that conversation with the other professionals on the file and say, what's going on here? How do we address this? And not let maybe one client's lack of disclosure per se derail the whole process, but stay in open communication with the professionals on the file at least, so that we can have an understanding of how we want to move forward, as opposed to it just sitting, in this abyss of a situation for forever. So, Cindy, what's it like? Oh, sorry, Jane, actually, what are your take on working with us neutrals? Let's hear it. We're willing to take it all.
Oh, I don't have criticism. Actually, I have so much respect for neutrals, and I'm so grateful when they chime in with process suggestions. And I hear you, Matt, when you said, hire you guys early. That's what we always aim to do. I get on my first call with the other lawyer and say, okay, these are the clients. This is the issue we have to overcome. Who can do this for us? We have a business here. Definitely, we're going to have to hire Matt or someone else, not as good as Matt, to be the CBV, and let's see what we're going to come up with. So I actually look to the neutrals to give us suggestions on the process. And some neutrals actually take on the roles of being sort of a project manager. I kind of love it when they do that. And I trust them if they tell us, for example, if it's a family professional, that they come to us and they say, for these clients, it's much better to meet in person. Because since the pandemic, we've pivoted to a Zoom environment, which is more cost effective for the clients, but sometimes it's not the best process for particular clients. And having said that, I always try to support the neutrals on files. But there are times when one of the clients just not working perfectly well with that professional. And, it happens when one of the most delicate things I've had to do in the past is tell a neutral that my client does not wish to work with them anymore after the file is started. So in this kind of a sticky situation, I think it's important, again, to be respectful and keep in mind, though, that this is not the worst thing that can happen on a file. And it's got to be normalized. It's also important to offer a team brief to that professional. In addition, it's important that the client who no longer wishes to work with a professional not be made to feel as if they did something wrong. And the remaining team, including counsel who represents the other client, that counsel must see this as an event that's not out of the ordinary, and we have to pivot quickly to continue working together to proceed with the collaborative process. So Cindy, what do you think?
Well, I think early on getting hired on a file early on is important, as both you and Matt have stated. It's also allowing, from my perspective as a neutral, allowing the lawyers to get to know me. Who am I? What's my philosophy? How do I work? And for them to be able to decide, would I be a good fit for this family? Because we do have different personalities, and not every person is a good fit for every client. I then also let the lawyers know that I offer a free consultation call with both clients. I won't ever just talk to one client. And in that call, I talk about my philosophy, I talk about my beliefs, I talk about what I can do for them in the process, but I don't allow that as the opportunity to understand their personal ideas yet. And then from there, I've had files where clients have not loved working with me. It's my responsibility to ensure that I'm showing up for them the way they need me to. So I will have conversations with that client to try and understand in a confidential space what their issue is and how can I do better? What do they need from me for me to do better to hear their voice? I will also reach out to the rest of the team to say, do you have any insight into why a client's having difficulty with me? As I said earlier, it's a team process and we all need to work together. And remembering that the client's in a heightened emotional state, not taking it personally is a key important factor. It's not about me, it's about what they're going through. And I find when we're able to address that, we're able to move forward on any of these challenges.
So I'm going to just jump in here. So sometimes, so we do need to shift. As I mentioned, we have to be flexible and shift in process. So how do we do this and protect the clients if the process has to shift? So by way of a wrap up kind of question, can we all chime in with maybe one thing that you might recommend? Matt?
Sure. I agree. I think it's about trying to fit our abilities to what the clients need. And so if they need that extra bit of hand-holding, then provide that bit of hand-holding. If an issue comes up, be flexible enough to be able to say, okay, we can address this other issue, and this is the impact of that, and here's the new timeline, and managing the expectations at the same time. And that flow, which you don't get in regular litigation, because all of a sudden you have a court date and the court, you'd have to go seek an adjournment. We have that ability within the process. So it's about using the process in its best ability to stay flexible as possible. Natalie, what's your thoughts on that?
So when the process shifts to mediation, I do ensure that the client understands that the mediator may not necessarily disclose everything said in the room to the other side. However, the mediator may disclose something that is said, and I think that is a nuance that needs to be appreciated. I help frame the client's viewpoints, goals, and interests in a way that will be persuasive for the mediator. And I also explain to the client the difference between viable claims as opposed to interests, goals, and preferences. That shift in process obviously very much dictates whether or not it's interest-based as opposed to rights-based negotiation moving forward. And I spend quite a bit of time talking about process options and identifying the best option for my client moving forward. What about you, Jane?
Well, sometimes the team also needs to make sure the clients are protected in the unlikely event that the file needs to go into litigation. So when I say unlikely event, I can really count on one hand where this has occurred in my files. Nonetheless, it is important to make sure that we're able to get ahead of the curve and make sure that some terms, for example, are papered in a partial agreement, especially if there's potential for one party to be prejudiced. And in some cases, even at earlier stages, we have to make sure that the PA reflects terms that protect the client's entitlements given the party's intentions. But just as a wrap up, I think in every circumstance, the team communication and respect for one another is key in determining the needs of every client in every file. It's always very customized. Cindy, parting words for us?
Parting words, in the words of the illustrious Stu Webb, father of collaborative practice, any process that keeps clients out of court is a collaborative process. So because of certain circumstances which we've discussed today, the usual collaborative process might not be possible. Shifting to dyads, triads, mediation, any different framework will keep the process going, helps the clients reach a settlement that keeps them out of court, and then we have a situation where the family wins all around.
Great. Okay. There's Daphne.
Thank you so much. What an incredible session on collaborative practice. Thank you, Jane, Matthew, Natalie, and Cindy. We really appreciate you donating your time to the summit today. So thank you so much.
My pleasure.
Thank you.
Thank you for having us.
Yeah, thank you. Just a reminder to the audience that session was accredited for 1 hour of professionalism content.